Good morning. My name is Karina Norberg, and I'm making this position statement on behalf of Lindsay and Luan Crane-Traeger, who have been sued by Jean and Constance Vernon. The defendants request the mediator to resolve the present dispute, taking into consideration that the plaintiffs have not provided sufficient evidence to demonstrate the existence of a contract for sale. The plaintiffs argue that on August 20, 2016, the parties entered into an oral agreement to sell Riot Foods and its assets to the defendants for $170,000. The plaintiffs also allege that the defendants paid $15,000 and promised to pay the balance as soon as their bank granted them a loan for the difference. Even though the defendants admit paying the alleged $15,000, they denied accepting the plaintiff's offer for the sale of Riot Foods. As Luan Crane-Traeger testified, the parties came up with a tentative oral agreement to purchase Riot Foods, but the defendants opted for not moving forward with the contract because at the time they did not have the amount of money requested by the plaintiffs. The defendants denied the existence of a transaction to which Article 2 might apply based on three main reasons. First, Section 21051 defines goods as all things which are movable at the time of identification. In the present case, the selling of Riot Foods not only involves the transfer of Riot Foods assets, but also the contracts secured by the company, the use of their brand, which are not goods as defined in 21051. Therefore, Article 2 would not be applicable to the sale of those rights. Second, the fact that the plaintiffs retain title to the truck and the trailer shows that the plaintiffs created a security interest in the vehicles. In other words, the plaintiffs accepted the $15,000, but by retaining title to the vehicles, they created a security interest in the vehicles to secure that the defendants would pay the full amount. Security agreements permit sellers the retention of title to the goods to create a security interest, but such transfers are not regulated by Article 2. Instead, they must follow the rules of Article 9. In other words, opposite to what the plaintiffs argue, Article 2 cannot be applied to the sale of the truck and the trailer. The defendants will not argue that the present transaction involved an option contract because firm offers, as defined in the UCC, can only be made by merchants. And to qualify as a merchant under the UCC, the plaintiffs must be engaged in the business of selling goods of the kind. Since the selling of Riot Foods and its assets was a one-time event for the plaintiffs, they would not be merchants as defined in 21041. Finally, plaintiffs' counsel has defined this transaction as a mixed contract. Per definition, a mixed contract comprises the transfers of goods and services. Here, none of the parties has admitted that the provision of services was part of the transaction, even though Jean Vernon worked for the defendants at two events. He rendered such services as an employee and was paid separately according to the number of hours he worked. Therefore, the defendants request a mediator to propose a solution that resolve this issue out of the provisions of Article 2 and focus instead on determining whether the parties formed a contract for sale under the scope of common law rules. Thank you.